Welcome to UXL, where you can learn new skills anytime and anywhere. Visit uxl.com to explore our full course selection. This lesson is part of a larger course. Check the video description below for a link to the full course where you can enroll. If you enjoy our content, please like and subscribe. For your convenience, the course cover displayed on your screen provides the complete course title and lesson title. Let's proceed with the lesson. Lesson: Employment Policies and Agreements. Employment policies and agreements are critical components of the human resources framework, especially in a state with complex labor laws like California. These policies and agreements not only define the employer-employee relationship, but also ensure compliance with state regulations, thereby mitigating legal risks. Employment policies encompass a broad range of topics, including but not limited to hiring practices, employee conduct, compensation, benefits, and termination procedures. Agreements, on the other hand, are formal contracts that outline the terms and conditions of employment, such as offer letters, non-compete agreements, and arbitration agreements. Mastering these elements is essential for anyone pursuing the Professional in Human Resources California certification. California labor laws are among the most stringent in the United States, necessitating meticulous attention to employment policies and agreements. For instance, the California Fair Employment and Housing Act imposes specific requirements on employers regarding discrimination, harassment, and retaliation. Employers must draft policies that not only comply with FEHA, but also promote a culture of inclusivity and respect. This includes clearly articulated anti-discrimination and anti-harassment policies, which should be communicated to all employees during the onboarding process. According to the California Department of Fair Employment and Housing, employers with 5 or more employees are required to provide harassment prevention training, which underscores the importance of robust policies in mitigating workplace misconduct. Similarly, wage and hour laws in California are highly detailed, covering minimum wage rates, overtime pay, meal and rest breaks, and wage statement requirements. The California Labor Code mandates that non-exempt employees receive overtime pay at 1.5 times their regular rate for hours worked beyond 8 in a day or 40 in a week. Additionally, double time must be paid for hours worked beyond 12 in a day. Employers must incorporate these regulations into their compensation policies to ensure compliance and avoid costly penalties. A 2019 study by the Economic Policy Institute found that wage theft, including unpaid overtime, costs workers in California an estimated $2 billion annually, highlighting the critical need for accurate and lawful wage policies. Employee onboarding is a pivotal phase where employment agreements come into play. Offer letters are typically the first form of agreement extended to a new hire, outlining the basic terms of employment, such as job title, salary, start date, and reporting structure. While offer letters are generally not legally binding, they set the stage for the formal employment contract. In California, it is advisable to include language that specifies the at-will nature of employment, meaning either party can terminate the relationship at any time for any lawful reason. This provision helps protect employers from potential wrongful termination claims. Non-compete agreements are another type of employment contract, although their enforceability is highly restricted in California. Under Business and Professions Code Section 16600, non-compete clauses are generally void, except in limited circumstances such as the sale of a business. This unique aspect of California law requires HR professionals to be particularly cautious when drafting any restrictive covenants. Instead, employers may use non-solicitation agreements to prevent former employees from poaching clients or colleagues, though even these agreements must be carefully crafted to withstand legal scrutiny. Arbitration agreements, which mandate that employment disputes be resolved through arbitration rather than litigation, are another common component of employment contracts. While these agreements can offer benefits such as reduced legal costs and quicker resolution times, they have been subject to significant legal challenges. The California Supreme Court's decision in Armendariz v. Foundation Health Psych Care Services, Inc., set forth specific criteria for the enforceability of arbitration agreements, including requirements for mutual consent, fairness, and the availability of remedies comparable to those available in court. Employers must ensure that their arbitration agreements comply with these standards to be enforceable. The importance of well-drafted employee handbooks cannot be overstated. These documents serve as comprehensive guides to the company's policies and procedures, helping to set clear expectations for employees. A well-crafted employee handbook should cover a wide range of topics, including attendance, dress code, use of company property, and disciplinary procedures. It should also include information on employee benefits, such as health insurance, retirement plans, and paid time off. In California, specific policies must be included to comply with state laws, such as those related to paid sick leave under the Healthy Workplaces, Healthy Families Act of 2014. Employers should also be aware of the requirements for employee privacy and data protection. The California Consumer Privacy Act imposes stringent requirements on businesses regarding the collection, use, and sharing of personal information. Employers must provide clear notices to employees about the types of personal data collected and the purposes for which it is used. Additionally, they must implement reasonable security measures to protect this data from unauthorized access. Non-compliance with the CCPA can result in significant financial penalties, making it imperative for employers to develop robust data protection policies. Employee agreements and policies must also address the evolving landscape of remote work, which has become increasingly prevalent due to the COVID-19 pandemic. Remote work policies should outline expectations for work hours, communication, and performance metrics. They should also address issues related to equipment and expenses, ensuring that employees are adequately supported in their remote work environment. According to a 2020 report by the Society for Human Resource Management, 67% of employers reported increased productivity among remote workers, underscoring the importance of effective remote work policies. In conclusion, employment policies and agreements are foundational elements of the HR framework, particularly in a state with complex labor laws like California. These documents not only define the employer-employee relationship, but also ensure compliance with state regulations, thereby mitigating legal risks. From anti-discrimination policies and wage and hour laws to arbitration agreements and remote work policies, HR professionals must navigate a multitude of legal requirements and best practices. Mastery of these topics is essential for anyone pursuing the Professional in Human Resources California certification, as it equips them with the knowledge and skills needed to implement effective and compliant HR practices. This concludes the lesson. We trust you found this video informative and engaging. To enroll in the complete course, please use the link provided in the description below. At UXL, we are committed to your learning journey. Each course offers a certificate of completion, online support, and downloadable resource files to enhance your experience. If you found our content valuable, we invite you to like this video and subscribe to our channel. Thank you for joining us, and we look forward to supporting your continued pursuit of knowledge.